Well, thank you everyone for joining us today. I'm glad to see that a number of my fellow sheriffs have logged on, and I'm thrilled to have so many staff from our member agencies joining us as well. We also have a number of municipal, county, state, and also a number of federal law enforcement agencies that are joining with us today. So welcome and thank you for tuning in. We began these webinars to be sources of crucial information and connection to our members. Our webinar series has not only been an opportunity for professional development, but also a chance for us to come together and be together to learn from outside experts, as well as from one another. This is our 9th webinar in the Critical Issues series. To date, we've had almost 2,000 individuals from inside and outside of major county sheriffs of America register to participate. I'm proud of what we're doing and that it has been so well received. And I say thank you to all for helping make that happen. I would also like to take a moment to acknowledge Vice President Dennis Lima, Sheriff of Seminole County, Florida, who works to build up our profession every day. He's a great partner, and he'll be a great president when he takes over from me during our winter conference in February. I also want to thank our corporate partners for tuning in, particularly our webinar host, Offduty Management, and a special thanks to Brian Manley, who is the company's president and retired police chief of Austin, Texas, and to Greg Duran and Tina Hendrickson from Brian's team. At this time, I'd like to pause for a moment to share a message from our friends at Offduty Management. Please watch and enjoy.
Hello, I'm Brian Manley, retired chief of the Austin Police Department and president of Offduty Management. As the head of your agency, you face daily crises and issues that demand your time, and it is likely your deputy's off-duty work rarely rises to the top of that list. A quick look at the headlines shows that off-duty job incidents are a significant threat to your deputies and agency. Tragically, there are new incidents each month where a law enforcement officer was injured or killed while working an off-duty job, oftentimes without sufficient insurance coverage. The families of these heroes are often left to navigate the difficult process of insurance while also dealing with the loss of their loved one. We offer a cost-free solution to protect and cover them in this time of need. Off-Duty Management was built by officers for officers and provides your deputies with a critical layer of protection they may not otherwise have while working off-duty assignments. Furthermore, Off-Duty Management provides your agency with comprehensive administrative services. Our skilled operations team manages coordinating off-duty job details so your deputies can focus on protecting your community. You don't have to worry about keeping track of job requirements. Off-Duty Management does it for you. You don't have to worry about reporting. We send you customized reports as you need them. Your deputies don't need to worry that they will not be paid on time. Off-Duty Management pays for hours worked within a week, whether the vendor pays us or not. Partnering with Off-Duty Management is one of the easiest and fastest ways you can provide your deputies with insurance coverage they may not otherwise have, while also reducing unnecessary costs from your budget. Please reach out to us and learn how we can cover your off-duty blind spot.
Thank you again to Brian and everyone over at Off-Duty Management, and thanks again for your continued support of Major County Sheriffs of America. As you saw from the invitation, today we'll be discussing the topic of consent decrees. As with everything we try to do at MCSA, the idea for this webinar came from all of you. You might recall that we spent time discussing this topic last fall at our conference in Boston, and it has been the discussion of many of us individually and collectively for months and even years. With the Department of Justice having just announced a pattern or practice investigation into a municipal police department in the state of New York 2 weeks ago, today's webinar is extremely timely. Pattern or practice investigations have been used by the Department of Justice since the late 1990s. As the Major County Sheriffs of America e-board knows, our organization has a very strong working relationship with the administration and leadership at the Department of Justice. Simply put, DOJ has been communicative and supportive of our organization. They have demonstrated a genuine interest in working closely with us on our shared mission of public safety. And just 2 weeks ago, I had the pleasure of sitting down with Attorney General Garland while I was in Washington, D.C., and have had many conversations with Vanita Gupta, Lisa Monaco, and Kristen Clark regularly and proactively, where they reach out to us to let us know what they are thinking, what are going on, and looking for input. I can tell you unequivocally that our voice as a professional association is important to the Department of Justice, and we have a place very much at the table with them. Today's topic, although not the most comfortable one to discuss, is critical for us to devote some time. I believe strongly that occasional self-assessments of the agencies we lead is critical to maintaining, and in some cases even earning, the trust of the public. Sometimes that means learning something that might have been easier not to know, but that's not why we do this work after all. We are leaders and we are problem solvers, and today's webinar will equip us with the tools and information to be better at that. In introducing our guest today, I'm honored to start with former Deputy Attorney General Rod Rosenstein. Attorney Rosenstein served in leadership positions under 3 presidents, including several years as U.S. Attorney for Maryland. While Deputy Attorney General of the United States, Attorney Rosenstein was the second highest ranking DOJ official from 2017 through 19, overseeing 115,000 employees nationwide in the litigating division, federal law enforcement agencies, and U.S. attorneys' offices. Attorney Rosenstein now works for the international law firm King & Spalding, where his practice is focused on special matters and government investigations. He brings over 3 decades of experience as a federal prosecutor and senior government official to his current position. Also joining us is Attorney Thomas Wheeler, another former senior official at the Department of Justice. Attorney Wheeler is the former Assistant Attorney General of the United States for Civil Rights. He also served as senior advisor and senior counsel to the Secretary of the United States Department of Education and as senior advisor to the White House Federal Commission on School Safety. Formerly the general counsel to the National Sheriff's Association and senior advisor to the Indiana Attorney General, Attorney Wheeler is now a member of Frost Todd Brown LLC, where he represents schools and law enforcement in litigation across the United States. Our third panelist is our very own Sheriff Don Barnes of Orange County, California. Sheriff Barnes was elected in November of 2018 in one of the largest counties in the country, and of course in California, with almost 3.2 million residents. As Sheriff Coroner, he brings over 30 years of service to the position, and leads an organization of over 4,000 sworn men and women. Sheriff Barnes is also the chair of MCSA's Intelligence Commander Committee. Now, at this time, I'm going to turn the program over to Attorney Wheeler and Attorney Rosenstein to kick off the presentation. We'll then turn the program over to Sheriff Barnes, who is intimately familiar with this topic, having inherited a DOJ investigation from his predecessors. Sheriff Sandra Hutchins as well, who we all remember very fondly, is a great leader as well. And Sheriff Barnes was able to see it to a conclusion. After all 3 presentations, we'll open up the floor to questions. As our presenters are speaking, please feel free to type any questions that you might have into the chat, and we'll get to as many as we can after we hear from all 3 speakers.
As independent experts, and they are responsible for working with the department and reporting to the court and the public. And then, of course, the issue of resolution, as I said, and as Tom Wheeler will discuss, one of the controversial aspects is how long these consent decrees go on. Ideally, a consent decree will contain concrete and measurable standards, which will enable the court to evaluate whether or not the consent decree has been complied with. And eventually there'll be a resolution. And the goal, of course, of these consent decrees is not for the federal government to be running the department indefinitely, but for the federal government to be working with state and local authorities to put in place proper systems so that the agency can be turned back to local control without concern of future violations. And Tom, slide 8.
So thank you, Rod. And I'd like to thank Sheriff Katijian and Major County Sheriffs for having us back again to talk about these issues. One of the things, and I want to touch on what Rod mentioned, one of the problems with consent decrees, and I've been on both sides of these, both on the DOJ side as well as on the law enforcement and the education side, is, as Rod mentioned, the court supervision. The problem with going into a consent decree, and we may hear about this from Sheriff Barnes, the problem with a consent decree is you lose control. The judge has control. And indeed, when the Baltimore consent decree, although it was negotiated, it went in front of the judge. The judge has full power to modify the consent decree. So you may negotiate all these terms with DOJ, but once it gets in front of the judge, the judge owns it, and the judge will have a hearing, and the judge may make changes. And this is why I think Sheriff Barnes' experience in working on a collaborative process with the department, if you can get through, and we'll talk about some methods to do that within the Department of Justice. If you can get through it without going into consent decree, you and DOJ retain control over your agreement. When I was head of the Civil Rights Division, I had agencies, law enforcement agencies, come in and want to talk about resolving the consent decree, handling monitor issues and things like that. And the problem was, even if we at the DOJ and the entity agreed, the court retains full control. Whereas if you have a collaborative process, you either mediate it, or there's a resolution agreement, or you use one of the other methods that I'm going to talk about, you and the DOJ control it. And you and the DOJ can control how the resolution agreement is enforced. You can change your goalpost. You can handle it. Again, you keep the control. When we go to a consent decree, the judge has all the control. Recognizing some of the concerns, and these were concerns that were brought to us by law enforcement. The Attorney General held several meetings with representatives of major law enforcement organizations in his conference room, where we talked about concerns about the consent decree. So he ordered a review of the consent decree process in 2017, and we tried to address some of those issues in that administration. As Rod mentioned, the current administration, Attorney General Garland, has kind of removed some of those guardrails that we had put up on consent decrees. And I give them great kudos, because they too, Attorney General Garland ordered a review of the consent decree process at DOJ, headed up, I believe, by Vanita Gupta, who formerly was the head of the Civil Rights Division during the Obama administration and was my immediate predecessor. And what's great about what they did is they addressed one of the biggest complaints we heard in 2017, and I'm sure they heard the exact same thing when they came in, involves the monitoring process. The problem that we saw with the monitors is that the monitors, as I said, you lose control when the court has it. The court relies on the monitors to determine compliance with the terms of the consent decree. There's inherent conflict of interest. When that occurs, the monitors are getting paid, and sometimes paid a substantial amount of money, to handle these consent decrees. And just to be frank, some of the concerns that we heard expressed by law enforcement was that there was no incentive for the monitors to resolve the consent decree, to find that the law enforcement agencies had met all of the milestones. And frequently we received complaints, and I'm certain that Vanita and her team, when they did their review, saw similar complaints based upon what they came out with, that we needed to get a handle on the monitor process. So the new process they announced after their review had 5 principles, and all of which are laudable. 1, they should be designed to minimize cost to jurisdictions and avoid any periods of conflict. That is to say, the monitor has an incentive, there's a disincentive to find full compliance with the consent decree. The monitors must be accountable to the court and the parties and the public. The monitors should assess compliance consistently across jurisdictions. We saw this, I'm sure they saw this. There were wildly disparate methods by these monitors in handling compliance and handling goalposts and handling reports to the court. Again, sustained meaningful engagement with the community. Sometimes the monitor talks to the law enforcement agency and the court, and community input is important into determining whether compliance is taking place. And again, monitoring must be structured to efficiently move jurisdictions into compliance. That is, you've got to have an end time. You're not caught. I know Seattle was caught in one for a long time and they couldn't get out. There's got to be an end point. Budget caps, again, these are what you'll see, and these are all, again, to kind of remove the incentivization of monitors to maintain the consent decrees. And again, budget caps, no double dipping, which is to say, we would see the same monitoring groups coming in on whether it was Baltimore or the other consent decrees we were dealing with. The court appoints the monitors, and the same people would come forward and they get multiple consent decrees I really like the no double dipping thing. Again, stakeholder input. Certainly law enforcement told us, and I'm sure told this administration, they didn't have any really any input in the process. But again, that's part of the control, which is when you sign a consent decree, you give up some of that control. Term limits, same thing. Keeping these consent decrees, get a specific time to try to at least have a review. And I think that they put in a 5-year review for a termination hearing. So that gets you out of these. I will tell you on the education side of my practice, I've dealt with consent decrees, particularly in the DSEG space, that have been around for 40 years and then saw it at DOJ in my education, the Civil Rights Education Division monitors those. And it is, even at that amount of time, it's extraordinarily hard to get rid of those. So let's talk a little bit about the process of an investigation and kind of where there are touch points to try to come to either a negotiated resolution or a mediated resolution or some other process to kind of stay out of the consent decree hotel, let me say it that way. With respect to this, and I think Sheriff Katijian mentioned this, the Civil Rights Division just announced their 4th pattern of practice. A couple of things about this announcement. This is out of the DOJ press release. One, it's typical of the Civil Rights Division. It is instead to note that these pattern of practice investigations are frequently enormous. I was in Louisville last week discussing their pattern and practice investigation after the Breonna Taylor matter. Obviously, the Minneapolis one, Louisville and Minneapolis in and of themselves take an enormous amount of staff time. If you look at the kind of things they're doing, as set out in the press release, they're meeting, they're taking input, they're doing ride-alongs, they're out there investigating these things, and it's just a very intensive process for these pattern and practice investigations. And you know, it also relies on a lot of cooperation with the local law enforcement agencies, and that's why it's so helpful. As I think Sheriff Katijian mentioned, that when you get into this situation, working with the DOJ in a collaborative process, it is both helpful and ensures that your concerns are met. Whether sometimes they're financial constraints, we certainly heard that there were situations where, particularly not so much in the law enforcement side, but in the jail and prison side, that had to do with when we were dealing with state prison systems, funding from the legislature. We were dealing with city or county jails that they, from the localities in terms of financing. There's just, some of those aren't within your control. And discussing that with DOJ in a collaborative process, I think is just really useful. So let's talk about, I mentioned CRT, or the Civil Rights Division is the acronym. So they have primary responsibility. These are the enforcement tools. This is kind of the toolkit that is used at DOJ. One, we have civil, both a civil side and a criminal side, and I'll talk about those in just a minute. The entities generally useful, as Rod mentioned, it's the Civil Rights Division along with the U.S. Attorney's Office. And then there's a series of collaboration tools, and I've got a couple of slides on that. The DOJ provides technical assistance. OJP, the Office of Justice Programs, provides funding. COPS Office provides a collaborative approach. And then, as I mentioned, there's conciliation tools, mediation, outreach, CRS, the U.S. Attorney's Office, the Civil Rights Division. Those are all access points to trying to move the ball on a collaborative phase. So real quick, DOJ's statutory authority 1, section 242, you'll hear him talk about that. That is depriving rights under color of law. So that picks up your police, corrections, probation, judge, prosecutor. It has to be willful. It has to be a civil rights, one of the kind of designated civil rights, race, color, race, national origin, religion, sexual orientation was picked up later in the Matthew Shepard bill. And there has to be bodily injury, sexual assault, or death to bring it into the criminal side. So that, as Rod mentioned, those are singles. So that would be, when we were there, that was Freddie Gray, that would be George Floyd, a single. Now, where there's an allegation, again, as Rod mentioned, of a pattern and practice that is beyond a single, which is that the department has engaged in a pattern and practice. There are multiple instances of these. That implicates what's called the special litigation section. And so what they have the power, they're not criminal, but they have the power to seek equitable and declaratory relief. And again, that's a civil remedy, as Rod mentioned. There's also some funding statutes that prohibit discrimination as well. And it can also result in loss of funding by CRT if they make a finding. This is the statute itself, the 14 141 statute. But again, it's basically, this is the criminal piece. So the common issues we see at the Civil Rights Division, we saw at the Civil Rights Division, 14th Amendment, due process, equal protection. A lot in the press now, 4th Amendment, excessive force claims. We would see stops, searches, arrests. Those would be sometimes referred to as the clean window or the Rudy Giuliani approach. When those were more zealously enforced, we'd get challenges to that, as well as First Amendment. But at their core, they're violations of constitutional and federal law. So what's the process? The process, first of all, when there's an incident, there'll be a preliminary inquiry by the Department of Justice, either from the Civil Rights Division or Civil Rights Division jointly, and usually jointly with the U.S. Attorney's Office. We work hand in glove with the U.S. Attorney's offices, as Rod mentioned, and that's a valuable relationship. And to be honest, that's valuable for you as a local agency, because the people that Maine Justice gets its information from are your local U.S. attorneys. They're the people that you work with every day. And those are the people that are going to be the most help as you move through this process. After a preliminary inquiry, if it results that there is some basis for an investigation, the investigation process begins. And that's what, as I think you saw from the press release, the December 3rd press release, that's the process of the investigation. DOJ will then issue a findings letter. And at that point, and this is your next step. Once you get the findings letter, that's your ability to negotiate a resolution. Sometimes that takes a while, and I think Sheriff Barnes is going to address that. But that's the space to come out and try to negotiate the type of remedy. Sometimes that negotiation results in a consent decree, as Rod mentioned in Baltimore, a fairly elaborate consent decree. Sometimes that negotiation may result in a more collaborative remedy of some kind that doesn't involve court involvement. But again, that's you have control of your process during that negotiation and selection of a remedy. There are times when that breaks down and then DOJ litigates it. But as Rod said, these are almost always prepackaged consent decrees that go to court where the parties have made it. The courts have the right to modify it, but that negotiation process is where you have control of your destiny. So I want to highlight a couple of agencies that you're probably aware who work with. I worked closely with them when I was at both the DOJ and also at National Sheriff's Association. The COPS office does great work, particularly the CRITAC, or the Collective Reform for Technical Assistance. What that allows you to do, and I've got the process down here. So this gives you, it's not self-reporting, but it gives you the opportunity to bring something to the attention of CRITAC and ask for help. It's not supposed to be a gotcha. It's supposed to be, bring it to us. We'll take a look at it. We'll work with you. They use sometimes independent experts. We'll provide you, the COPS office will provide you with technical assistance, that is experts looking at your policies and procedures, looking at specific issues that you have that could arise at some point to a pattern and practice claim, but this is a way to kind of short circuit the process. And then what CRITAC, they'll work with you to develop a work plan based upon that technical assistance. Can look something like provisions in the consent decree with metrics, process, how do we get there? How do we measure whether we're reaching our goals? And it's an excellent process to go through. If you're in a situation where you've had something, you think there's something, you have concerns, and you need that kind of expertise to come in and help. Finally, OJP actually, and this isn't used as much, but OJP also provides technical assistance to their diagnostic center. It's a little bit more of a data-driven, it's like anything OJP's, it's a data-driven process. But again, it's another option to try to get assistance before you end up in a full-fledged pattern and practice investigation. And it gives you that chance to keep control of your situation. So with that, Rod, if you don't have any comments, I'll turn this back over.
Thank you very much, Tom and Rod, for your informative presentations. I can think of a few questions myself, but I'm going to hold them. I'm going to remind anyone that has any questions they'd like to propose to do so through the chat function. We've already received a few already, and we're eager to hear some more as long as we have as much time as we can to answer them as well. Now that we've heard from the perspective of two former Department of Justice officials, we're going to hear the perspective of a fellow sheriff and colleague and a friend, Don Barnes of Orange County, California. Don?
Thank you, Peter. I appreciate it. And I want to thank Mr. Rosenstein and Mr. Wheeler for their presentations as well. I'm going to start off with a little bit of a different perspective on what I went through our civil rights CRT investigation that might contradict a little bit of what was presented, but I think it ended well, and that's what I really want to focus on. But to set the stage, if you want to go to the next slide, please. To set the stage of where we were, I actually was working in one of our main jails. Get the next slide, please. There it is. Stay on that one, please. At the time, next one back, please. Back one. I was a lieutenant working in the jails when we had the incident that was referred to that brought to the attention of CRT for a pattern of practice. It was the death or murder of an inmate entrusted to our care at our Theo Lacey facility. It was actually one of the watch commanders at the Central Jail Complex at that time. I had worked the jails for many years, but I was back there as a watch commander. Orange County jail system is a mega jail. Our normal population is about, our cap, I should say maximum, is about 6,200. This is what existed at that time. We have 3 jails that comprise the Central Jail. They're older jails. One is over 50 years old. It's a linear style jail that creates significant issues with watching people from a catwalk. Our newer facilities are all direct supervision models where we have somebody in a pod and it's kind of sliced off and you can see that. The Theo Lacey facilities are largest, and that's where this incident occurred. And it has it's a composition of actually 3 different types, and one of them was barracks housing, and barracks housing is very difficult. And that's where this incident occurred because there were a lot of blind spots in there. That said, that happened in 2006. That was under then Sheriff Mike Corona. He was eventually indicted on separate issues and went to federal prison. I can say that from my personal belief with him, he lacked leadership qualities to actually lead an organization and made it very difficult for us to manage because of what his expectations or how low his expectations were and not causing problems with our staff. In other words, not holding them accountable, a separate issue entirely. That's where we were then. A lot of the issues we faced were revolving around that. So now if you go to the next slide, please. We'll fast forward. Mike Corona left office. Sandra Hutchins came in 2008. I was actually working with Sandra Hutchins as lieutenant when as her chief of staff, if you will, when the CRT investigation started. And it was 11 years total, different iterations of engagement and involvement with CRT. We had a lot of times where they just went dark, no communication at all. And I think it became very frustrating for me as then 11 years later, I'm now the sheriff, started the investigation lieutenant, promoted through the ranks. And now I inherited it once again as the sheriff when I took office in January 2019. And I'm going to use this reference that when I was working through these issues throughout the 10 years, and I shared this with CRT, I felt like Bill Murray in Groundhog's Day. I felt like every day I was waking up to this continuing investigation that seemed to have no closure in sight. And we had various levels of engagement. At one point, we were down to one singular issue, and that was the carotid control technique that the CRT wanted to see abolished. And Sheriff Hutchins said, no, it is a valid martial arts technique for getting people into compliance or custody. And we were down to one. And then we didn't hear anything for years. And in 2009, we got 33 new findings and recommendations out of nowhere. And it was really striking to me that we were down to one item and we got 33 more. And this is kind of contrary to what, contrasting to what was presented by Mr. Rosenstein, Mr. Wheeler, is this really difficult environment that's resource laden, drawing resources constantly, document production and satisfying some of the findings that are coming forth. And to have these 33 were very troubling to me and had to do with inmate classification. And I'm going to tell you a quote that really got under my skin. I was talking to CRT investigators, and the question I asked was, tell me where in the nation is an industry best practice classification system so we can look at it, model it, emulate it, and implement it in our jail to satisfy the concerns of CRT. And the response I got from the attorney was, I have no idea. I have no idea how to run a jail. And that was very alarming to me to get that response. And so we met with CRT in DC and talked about the frustration that I had been going through for years as seeing this investigation, and proposed an alternate strategy that would bring this to conclusion. At no point were we adversarial in trying to address the issues. And with that view, it seemed like, why aren't we pulling the rope the same way to try to get to resolution, implement solutions that work? The one thing I will say that, and this may be something that Mr. Wheeler said, and I will tell you this is not the response I got. We had mentioned numerous times to bring in subject matter experts, other federal partners to help us. And at least at the investigative level, we were told repeatedly, you cannot bring in any third party, other federal agencies while there's an open investigation. And that's frustrating. We have topic matter experts and subject matter experts who know these issues and can come in as a partner for both of us and rapidly bring to resolution of industry best practices. And we're told that's not allowed to happen during an open investigation. So it was a little frustrating to have that happen. If you see the timeline here, I'll get to the end to open up for questions. And what we proposed, this is with the collaboration of Steve Cook, who's on the call with us today. Steve Cook was in DOJ at the time, and others, and with Mr. Rosenstein's, I think, assistance, and with other partners from National Sheriffs, Carrie Hill, who now works for Peter Katusian with the State Sheriffs Association of Massachusetts. I'm sorry, the Massachusetts, I think that's what it is, and others, including BJA and NIC, to come in and solve some of these problems. And here's an example of what we did. We brought in, this is where the monitors and SMEs that was mentioned, gets really tricky, because one of the issues we had was identified in our classification system that we wanted to remedy. We had I believe, a current and contemporary system we modeled after San Bernardino Sheriff's Office that we wanted to implement, and we did. And the validity of it was questioned because there was a model that's been in place for 2 decades, and that is, in CRT's belief, the one and only model that can work. And we said, it's not true. This will work much better. And we implemented it. And what I love about the new model is resulted in out of cell time for inmates entrusted to our care by as much as 400, 800%. And that's really what we're hoping to do. Changed our classification system on its head, the way we look at the classification and how we have to keep our inmates safe. And I think there was an excellent outcome for us. So if you go to the next slide, please, and I'll tell you what we ended up doing. And rather than being adversarial, we became participatory. And I really have to brag on Laura Cowell, who was in CRT. She took the lead on the investigation part of it and started working with us, especially when you have a leadership who wants to be collaborative in solving problems and isn't being adversarial. And I think that both Mr. Rosenstein and Mr. Wheeler will agree that there are times where you have to come to some type of resolution through consent or some type of agreement. We were able to bring to resolution our investigation in less than a year. I want to say in about 7 months. We implemented the new objective classification system I referenced. We added 3 new behavioral health modules in our jails. We increased staffing ratios where necessary. I ended late night releases so people can walk in the arms of other people rather than walk out in the middle of the night and be preyed upon, especially for women, by drug dealers and people who want to traffic them. We opened a housing unit for military veterans, known as Humvee, specific for people serving. Since then, we now have opened a TAY unit, transitional age youth unit as well, focused on the 18 to 25-year-olds that are high risk. If they get to 26, they're going to be in the correctional system for many years. Have a substance use step-down unit any given day, up to 100 to 120 medically supervised people detoxing off of alcohol and or drugs. Implemented MATs many years ago, cost me $2 million a year to do that. For opioid treatment, I have between 575 and 750 people in the MAT program. And then intensified reentry program, we have a new facility coming online probably in about 18 months that is reentry specific and the focus. When I mentioned mental illness, and this is nothing new to the people I'm talking to, but we have on any given day between 1,900 and 2,000 people on a normal population is down because of COVID right now, who are receive a daily nexus to mental health treatment. And through all that, we have programs now to tie them to out of custody sustainability and success when they transition out into housing or into programs or into drug programs, whatever it may be, if they're willing to receive those offers of help. So in short, we did that through a collaborative approach. We called it it was really a one-time kind of pilot program that we used. It was participatory, and it was aimed at solving the problems collaboratively that will then end the investigation. And I'm proud of what we accomplished jointly. I'd hope that under this new administration, that CRT would look at what we accomplished in Orange County and emulate that wherever possible when there are sheriffs or police chiefs who aren't being adversarial, who want to have the same resolution with positive outcomes, and use this approach, emulate this approach, because I think it worked very, very well. We're able to bring our investigation to conclusion without any findings or any recommendations, which I think was a tremendous effort on both parts. Very proud of that. I think there's maybe one more closing slide, or it's just ended. That's it. These are the next slide. These are the partners we brought in. And I think it's important to reference this. We had Kerry Hill, really, who was representing National Sheriff's Association at the time, NIC, which we dealt with, and is now working towards validating that classification system that we had mentioned earlier, and of course, BJA for some of the technical assistance that was offered. But I want to be clear, we were told for years, we could not bring outside assistance in, and I just want to make sure if that is still a position that exists within CRT, that really needs to be corrected. You have to have the topic matter experts, the technical assistants, and the SMEs who know how to pull the rope the same direction to solve these problems. Thank you again for the opportunity to present, and I'm very proud of what we accomplished here, and I think there's tremendous opportunity going forward. I will end it to just Peter Katusian that started with. I was able to spend probably about an hour and a half on the phone with Vanita Gupta's staff about some of the concerns that we saw. And I think what occurred several months ago with the recommendations for monitors and how they work was a result of our major county sheriffs and conversations we've had with Vanita Gupta's staff on helping to improve the process to bring these under better controls. I think that's necessary as well. Thank you for the time.
Thank you, Don, for that presentation and your personal insight on the topic. And you're right, Don, you spent a lot of time with Associate Attorney General Gupta. When I got the very first calls, as these were going to be the nominees from the administration, they reached out to the president of the different organizations. We had our initial just commentary. Hey, these are things that are important. Look forward to speaking with you as an association about these. Because of your experience and my own experience, quite honestly, back here in Massachusetts, these were some of the very first things I mentioned. It was great to see Kristen Clark and Vanita Gupta and Lisa Monaco all understanding how important this was to sheriffs. And you are a great example of what you had to go through under Sheriff Hutchins and how you were able to resolve it. To Rod and to Tom, I'm just curious if you'd come back on screen. When I became sheriff, I inherited it was a consent decree, but it wasn't Department of Justice. I don't even call it technically a consent decree, but it was issued by the courts here in Massachusetts, an overcrowding. We were in compliance with it, but it went on for far too long. And like Don, I actually addressed it, brought it forward, and reached out to the other organizations that had brought the suit. Prisoner Legal Services, I believe ACLU was also involved, and was able to use them to bring this to resolve the issue and to close it out. I was also able to use them to get things done for my facility that I wanted to get done for my facility, right? Because I know that in some of these cases, the executives themselves, the sheriffs, the police chiefs might have wanted to do certain things, but the state or the county were not giving them the resources or the support that they needed to do what they wanted to do. So I'm curious, in how many times, or is there a good example of one of these being used for the benefit of the executive leading that organization to do what they had been trying to do for a long period of time, but were unable to do because of those that were resourcing them or that were, dictating to them to some degree how they should manage their own operation?
Rod, I'm happy to go ahead, Rod.
Just way of introduction. I think, Sheriff, that was certainly one of the issues in Baltimore. Kevin Davis, who was the police chief at the time, was hopeful that the consent decree would result in additional resources for the department. So I think that can play a role. And Tom, you might know about other instances.
Yeah, so early on when we came in, similar to what the Baltimore proposed consent decree, Chicago was in the midst, the city of Chicago was in the midst of a pattern and practice investigation as a result of Laquan Taylor shooting that was fairly highly publicized. And I specifically recall meeting with the FOP, actually, who brought up the exact same issue, Sheriff Katijian, that you mentioned, which was part of the reason that that situation occurred, they felt, was lack of training, and particularly the failure of the city of Chicago to properly fund training. They were understaffed, they didn't have it. And although Chicago didn't go to a DOJ consent decree, I think that's a motivation. That is one benefit of a consent decree, which is that the court can order resources. And I mentioned that we had the state of Alabama had a hideous jail system, and the legislature had no interest in funding their jail system. I mean, there were beatings, there were fight clubs. It was horrendous. And so a consent decree does provide exactly what you're talking about, Sheriff Katijian. And I really want to emphasize that something both of you have said that I experienced. I mean, sitting in the AG's office with organizations like major county sheriffs, national sheriffs, major city chiefs of police, and raising the issues just like you did. This is I'm not shilling for the major county sheriffs here, but it is so important for somebody sitting on the other side of that table to hear from you guys about your experience, because it does make a difference. Sheriff Barnes, you mentioned your experience in monitors. The monitoring process is horrible. And they listened and they made that change. That was huge. We heard it, and I think this led to the collaborative process, Sheriff Barnes, that you were talking about in 2017 and 2018 from the same organizations, which was what led to Attorney General Sessions issuing his hold and review on consent decree. That resulted in giving Steve, Rod, myself, giving us the flexibility to knock yours out. It was, again, the willingness to come in and say, hey, we have a problem, help us work to fix this problem. The system's broke. If you're going back this direction, think about this, think about that. And it is to the credit of both sides that although they announced a refocus on consent decrees, that they also announced the changes to the monitoring process. If I'd been sitting over there, I would have liked to seen some other changes as well. But that's the engagement process that you guys talked about. And I just wanted to make sure that people understood how important that is for the people sitting on the other side of the table.
Tom, this is Don, and I totally agree with you, but I have to tell you, and I wish this is shared, and to you, Rod, this is not new. You've heard this before. I think there's a belief, not only among the sheriffs, but among the chiefs, that CRT measures success by how many consent decrees they see that as a victory. And I don't disagree that there are times when you can have an opportunity to bring resources or improvements because local government, the other facets of government that need to support those resources aren't doing it. And those opportunities are there, or those challenges, I should say, are there as well. But I think the one frustrating aspect of this, not to relive this, but it takes so long to get to some type of recommendations or finality. And it seems like every time there's a conversation on a topic, years go by, and I'll tell you my example. We were dealing with, I think, was mental health issues. We resolved those issues, and then somebody comes back out 3 years later, and they say, "Yeah, we'll talk about mental health." They go, "Oh, we're not the mental health people. I'm the classification people." And they come out for 3 years, and then you go through that process, and then you go, "Hey, we're here to talk about classification." And they go, "I'm not the classification people. I'm the ADA people." And they have these different teams. It just seems to me that there should be a centralized focus on looking at the civil rights issues and say, this is what we're going to look at, instead of going down all these rabbit holes over a decade or sometimes decades that never seem to have some type of structured finality. And I know that we don't have the luxury. We look at criminal investigations. I can't take, unless it's a cold case, obviously, but you have to have some type of finality in that investigation. And I think that's part of the frustration. It gives at least in my opinion, and what I've heard from others, it seems like the strategy of CRT is we're lawfully here and we're never leaving. At one point I asked, I think it might've been, I don't think you were in the room, Mr. Steen, so I don't think you're privileged to this conversation that I had. But the conversation I asked was, show me where in CRT's history you successfully ended an investigation. And they couldn't provide me one without a consent decree. They couldn't provide one example of how an investigation had come to finality or conclusion without some type of consent decree others. In other words, they're kind of lying in wait forever. They never close them. And it's very frustrating because it takes tremendous resources on our side of the table to be responsive to the numerous document requests. I mean, we've put dozens of people on this investigation for years at our resource. I didn't get new resources to go do that. I had to repurpose staff off of issues that could have been collaborative and result in a positively improved work environment if we had this how we ended in year 11. If we started in year 1 with that, and I don't think it would have worked back then, honestly, because it was a different sheriff. But then when Sheriff Hutchins came in, I think it could have been easily implemented years earlier and brought to conclusion. And I would highly stress to look on the timeline of some of these. I know you're both retired, but I still think you have influence into CRT to look at the timeliness and the length of time these goes on. So at some point, you just have to either find the violation you're hoping to find, or you have to say, look, we're done. We've looked hard, we've looked long. They've improved, they're doing a good job, or we didn't find what we're looking for, and kind of wrap up the business and move on. I may have sounded callous. If I did, I apologize. It's just very frustrating, I think, for people going through these year after year after year investigations with no end in sight.
I think, Don, that Tom, I'll get right to you, but I think, Don, that's exactly what I think. In Tom and Rod, you might be better able to speak to this, but what I believe that the DOJ did was almost more putting systems in place to police monitorings, right? Because I think the real issue was, as you said, Don, it went on, it morphed into a new thing. It became full-time employment, long-time employment for monitors. And the courts don't seem to really know that much or care that much, and they're not certainly spending the monies on those things and don't seem to rein in themselves. So it's up to the DOJ now to put in some guardrails, I think, from my recollection, Tom and Rod, that they were trying to put in some guardrails in place. They had more work to do. I think they said this was the first stage to what they hoped to continue to do. Can you describe a little bit about what they just did and what maybe they're planning to do in the future as well?
Rod, you want to take a swing at that, or?
I'll defer to you on that, Tom.
Okay, so I'll do that by answering a question Don had, because take someone like me that spent 35 years working with and representing law enforcement, frustrated with exactly what you're talking about, drop me into running the Civil Rights Division, pop me in on the other side, all right? One, there's a reason I asked for Hotel California as the lead song to this, because my experience in these is you can check, you check in, but you can never leave, right? Check out, but you can never leave. And I can't tell you how many people beg to help getting out. As the political appointee heading the Civil Rights Division, I had exactly those same frustrations. I remember sitting in my conference room with my DAGs and my section chiefs. And when the AG issued his order on consent decrees, which was to put a hold on consent decrees pending a review by Rod's office, Steve Cook, those guys. And I said, stop, just stop. And they were very concerned because that's the way they had always done it. Don, it's exactly what you were saying. And it was, we fought that all the way through. I think Steve would attest to that. Rod would attest to that. It's that mindset. It's kind of the career attorney mindset. This is the way we've always done it. And this is the resolution, right? And that's, again, why I wanted to emphasize what you were able to do with kind of the tamping down of the use of consent decrees. I think that allowed more options to do what you did. And so I think we've made a part. Now, where do I see us going in terms of this? Next piece, there's got to be follow through. I mean, the Civil Rights Division, the thing to remember is it's very small, okay, relatively speaking. Rod mentioned, or Sheriff Katijian on the intro, 115,000. I think for all the sections, there were 550. As I recall, the criminal division on special ed had maybe 70 attorneys. The pattern and practice investigation division was probably a little smaller than that. I'd have to go back and look. I tried to beef up the criminal side, but the bottom line is their resources are very small. And so if you bite off more than you can chew, Minneapolis, Louisville, et cetera, what's going to happen? In their case, when we got in, they bit off Chicago. Chicago was getting the same experience. I remember Eddie Barnes and Rahm Emanuel complaining about exactly what you're complaining about when we went in, which is it just stayed on. What they're going to have to be careful about is biting off a lot of these because they don't have the resources to do it. But once they start, they can't stop. And so, Sheriff Katijian, to answer your question, this is the fourth one, and they've got two really major ones on. And if they start looking at other entities as we have more incidents, I think we're going to see more languishing. As you know, it's terrible. Like I said, I saw the education ones have been there for 30 and 40 years. It's ridiculous. I completely agree.
Tom or Rod, is there any difference in the length or the scope for a patrol versus a correctional, pattern of practice or consent decree? So
my experience is that the jail ones are a lot longer. I mean, the patrol ones tend to be, one-offs, even if you get it. But here's the problem with the pattern and practice. A problem with the pattern and practice is it depends on the scope of the investigation. If you're going in and you're doing an investigation, and you're going to find, it's like the IRS, right? All right, the IRS is going to come in and they may look at your tax year 2018, but they're going to ask for everything, and they're going to dig around and they're going to find something. Where you have limited, targeted pattern and practices, and I think that's much easier to do in the patrol side. It goes quickly. It's pretty easy to resolve. The volume of what you're doing is reasonably small. But if you keep moving the target, and Sheriff Barnes, I think that's exactly what you said. They were looking at this and then they went over here. And to be honest, the jail, the prison situation, there's just a lot more targets. And so those tend to just broaden very rapidly. And then they're just difficult to control because they're resource rich, not only from the entity side, as Sheriff Barnes mentioned, but also from DOJ side. And it's difficult to allocate those resources because you've got to pull U.S. attorneys out of very busy districts and et cetera. So yeah, if we can get them to target those investigations on either side, and as you're communicating with them, go for more targeted. Don't go with give us all your data and we'll try to figure out what's going on. If you can convince them to take a more targeted approach, I think that's going to benefit everybody on the pattern and practice side.
Yeah, I agree. And I want to leave maybe one last question for DAG Rosenstein. And by the way, and I agree with you, Tom, we all know, we should know that our correctional side are the highest liabilities for us anyway. And whether that's on, overnight arrests or they're in our facilities, that is our greatest exposure right there anyway. And I can see where they would morph more likely because you bring everyone under one cover and you've always got problems in there as well. For Rod, I'm just wondering, do you know, could you explain how is a preliminary inquiry initiated, and what's the threshold? And is it started by DOJ? Is it started by outside parties? How does it begin? Like we always hear when it's announced, but we don't know how it began and who started.
Well, it started by DOJ, and typically either Main Justice or the U.S. Attorney's Office would raise the issue. Most of the investigations, though, as we discussed earlier, arise from particular high-profile incidents, but not always. And Tom, I think we had one on our watch that arose without any major publicity that was developed internally. But for the most part, Tom, I think they're the result of a high-profile incident. Isn't that right?
Yes, sir. And can I add something, Sheriff, on to Rod's? And this is an experience I think you had. Sometimes other entities jump in and you can get consent decrees by private entities, as you talked about. Let me give you the example of Chicago. We were working out a negotiated agreement, and then the Attorney General for the state of Illinois, I think it's Lisa Madigan, somebody correct me, She went ahead and filed suit while we were still negotiating. And now Chicago has a consent decree, as I understand it, with the state of Illinois, as opposed to the collaborative approach we were trying to do. So there's as you said, there's a lot of different players that can jump into the space.
Oh, that's great. Well, I just want to say thank you to our presenters today. It was a great conversation. I know we could go on a lot longer. There will be a recording of this posted, for those that are interested. And I know that people can reach out to Major County Sheriffs of America for any further information as well. I know that it's going to be a topic in which we remain invested. And we are, MCSA, are committed to collaborating with the Attorney General Garland and his team at DOJ. And I'd like to say, once again, thank you to our speakers, former Deputy Attorney General Rod Rosenstein of King & Spalding, LLP, Attorney Tom Wheeler from the law firm of Frost, Todd & Brown, or Frost Todd Brown, LLC, Sheriff Don Barnes of Orange County, California, and our Major County Sheriffs of America team, our Executive Director, Kim Wagner, Donna Stark, our Director of Administration, our General Counsel, the inimitable and great Steve Cook, who everyone on this call knows and admires incredibly. He's a great leader who has been instrumental in helping make this happen today in guiding our association with legal issues. And our vendor, IMN Solutions, particularly Morgan Lucchese. And finally, my team here at the Middlesex Sheriff's Office, Sean McMaster, Brendan Kennedy, and Morgan Rumpf. I feel like these are at the end of the movie, you run through the credits actually you have to by law, I suppose. So I just want to say thank you to everyone for helping bring this together. And as we close out, I'd like to let everyone know that we're working with DOJ to schedule a webinar series for our membership in January. We're hoping to be a 3-part series, which will be really open and discussive with leaders of Department of Justice. We're hoping it'll provide members the opportunity to hear directly from top DOJ officials about their vision on important topics such as criminal justice, homeland security issues, and other important law enforcement topics that impact us on a daily basis. So there's more to come on that in the next couple of weeks. So please stay tuned and tune in on those days. Have a great rest of the day. Please enjoy the holidays. Merry Christmas. Happy holidays. Be safe and be well.